What's up, everyone out there in Facebook world, YouTube world, social media world, the world, wherever you're watching this video at today? Welcome to another episode of Musings with MGL. I'm your host, as always, MGL. As you can tell, I am not in the studio today, but seeing how we are in lovely, beautiful Florida, the weather down here right now is gorgeous. So I figured, let's do one outside today. The weather's nice. I don't want to be cooped up in a studio. If anybody's watching this that's somewhere not other than Florida, you can be all gel about how awesome the weather is down here, and that we can do these videos outside on a lovely, lovely March day when a lot of the other country is under snow and rain, etc., etc. So, welcome to another edition of Musings with MGL. If you like what I have to say, as always, like, subscribe, share, yada yada. Got to get that out of the way. I wanted to crank out this quick video. That's another reason why the studio is not all set up too, because not only is it gorgeous out, but I really wanted to get this video out today because I got some breaking news, hot off the presses information that I kind of wanted to share with everybody and get it out there as fast as I can. So, as many of you know, especially here in Florida, several years ago after the shooting at the Marjory Stoneman Douglas High School, the state of Florida passed one of the worst anti-Second Amendment legislations in history. It was the Marjory Stoneman Douglas Act, which did a whole bunch of crap, like created red flag laws, etc., etc. One of the other things it did, one of the worst things that it did, was it restricted buying and possessing firearms to anyone under the age of 21. It used to be in Florida that once you hit 18, you're an adult, you can purchase a handgun, you can purchase a rifle, all that kind of stuff. There weren't any restrictions on that. You were an adult just like anything else. If you're old enough to serve in the military, you're old enough to possess a firearm. After the Marjory Stoneman Douglas Act, they passed a law, or a provision in that law that said you can't do that anymore. You have to be 21 years and older to purchase a firearm. There are some caveats in there about possessing them. You're allowed to possess them, and you can have them handed to you and given to you by family members, etc., etc., but you can't go into a gun shop and buy one, or even really buy one from a private person anymore unless you're 21 years of age. Well, that was challenged. The NRA, I know a lot of people hate the NRA and give the NRA a bad rap lots of times. Some of it's deserved, but regardless, in this particular case, the NRA filed a lawsuit. That lawsuit was appealed. They lost. It went to the 11th Circuit Court of Appeal, and the ruling came out today. So here it is, National Rifle Association and Radford Fant versus Pan Bonnie. She was the Attorney General at the time and the Commissioner of the Florida Department of Law Enforcement. Now, I'm going to read you the first couple pages of this because you can probably get the gist of what this ruling is once you read through this. So, and keep in mind as you're reading this is not a article on the MSNBC or on the New York Times. This is a written Circuit Appeals Court opinion for the Northern District of Florida. So, I'm going to start reading it because you'll get the gist of where I'm going. In Ohio, a 19-year-old son shoots and kills his father to avenge the wrongs of his mother. In Philadelphia, an 18-year-old youth shoots a 14-year-old girl before turning the gun on himself because she would not love him. In New York, a 20-year-old shoots and kills his lover out of jealousy. In Washington, D.C., a 19-year-old shoots and kills his mother, marking another death due to, quote, the careless use of firearms. In Texas, a 19-year-old shoots a police officer because of an old feud between the police officer and the 19-year-old's father. These stories are ripped from the headlines. The Reconstruction era headlines, that is. Oh, again, these freaking people could be writing for the damn New York Times. The stories are ripped from the headlines. The Reconstruction era headlines, that is. But they could have been from today's news. Unfortunately, they illustrate a persistent societal problem. Even though 18 to 20-year-olds now account for less than 4% of the population, they are responsible for more than 15% of homicide and manslaughter arrests. And in the more than 150 years since Reconstruction began, guns have gotten only deadlier. Automatic assault rifles can shoot 6 rounds per minute with enough force to liquefy organs. Yes, let me read that paragraph to you again. And in the more than 150 years since Reconstruction began, guns have gotten only deadlier. Automatic assault rifles can shoot 60 rounds per minute with enough force to liquefy organs. Tragically, under 21-year-old gunmen continue to intentionally target others, now with disturbing regularity in schools. So along with math, English, and science, school children must become proficient in running, hiding, and fighting armed gunmen in schools. Their lives depend on it. So, Can you guess, based on what I just read to you, how this ruling went? Spoiler alert, it didn't go real well for Second Amendments. They upheld the law by saying that there is a historical precedent keeping children from having firearms. That historical precedent is not the Second Amendment in 1776, or when it was actually passed, obviously a few years later, but Reconstruction era. If any of you know a little bit about history, Reconstruction is after the Civil War. So after the Civil War, we had the Reconstruction period in America. That was over 100 years, or around 100 years after the Second Amendment was created. So during Reconstruction, there were some laws passed about not having firearms for minor people. Now, I would argue that most of that had to do with, what else was in Reconstruction? Oh, that's right, it ended slavery, and all of a sudden, black people were created to be citizens, which they had never been before. And my guess is a lot of those laws were intended to keep young black men from having firearms out of the standard racist crap that you got back after the Civil War and the Reconstruction era. But they don't really want to go into that here. My guess is because Democrats were the ones who were doing that, so they didn't really want to go into that here. But I'm not going to read the entire article. It's several pages long. But look, historical sources from the Reconstruction era are more probative of the Second Amendment scope than those from the founding era. So that's all you need to know right there. Not to get too big in the weeds, but remember, Bruin was the most recent Supreme Court ruling that came out and said, in order to pass Second Amendment laws, there has to be a historical precedent for those laws. If there's really no historical precedent for those laws, then you can't pass them. Well, the way that this court decided to dick around and trick around and get around that rule was to say, well, there is historical precedent for the laws because these laws were during Reconstruction era. And we think that is a more important, that's what the word probative means, a more important historical era in American history than the actual freaking founding era where they created the damn Constitution, the Second Amendment in the first place. So this court decided that the era 100 years after the era that the Second Amendment was written is more important than the Second Amendment era. And based on that, they found through this stupid trickeration a way to uphold this law that is consistent with the Bruin decision by saying, oh, there is historical precedent because during the Reconstruction era, they had all these laws that said juveniles, or not juveniles, but people under the age of 21 couldn't have firearms. And remember, they were also telling them that they couldn't vote and they couldn't do all these other stuff because, again, Reconstruction era, the South, I wonder why they didn't want certain people having firearms when they were young back then. So again, I'm not going to read through all this. You can read it. I'll put a link in the description below. But basically, the bottom line is this was struck down. The NRA filed a lawsuit to challenge that provision of it. It finally made its way up to the Circuit Court of Appeals, and the Circuit Court of Appeals dismissed it, or ruled against them. I shouldn't say dismissed it, because now they can appeal and go to the next step. Also, I'm not sure, but I think this wasn't the full court ruling. It was just the 3-panel judges, and so usually in a Circuit Court of Appeals, there's like 7 judges, but they only have 3 do an opinion, and then if you don't like what they rule, you can ask for the full court to do the opinion. So they may ask for the full court to weigh in on this. Maybe it gets overturned, or they may just skip that and go straight to the next step. My guess is if this makes its way to the Supreme Court, I'm hoping that they'll strike down this rule. But for right now, the next step was this appeal to the Circuit Court, and there you go. The New York Times editorial board apparently works for the Supreme Court clerks and the appeals court clerks, and decided to write their opinion for them, because when you read through this, it reads 100% like something you would see in the New York Times or on Bloomberg's website or the Gifford's website or whatever. This is an atrocious decision. As a lawyer, it makes me weep to read decisions like these, because they are clearly finding just bullshit ways to rule the way that they are. And when you put the political statements at the very forefront of it, it makes it clear why they made this ruling. It wasn't based on any sort of sound judicial policy. It was based on politics instead, and unfortunately, that's what we're stuck with. So breaking news, the most recent appeal on this issue has been denied. They're going to keep fighting it. They'll keep appealing it. When things keep happening, I'll let you know. But just keep in mind, we have some good judges out there in some circuits, and the Supreme Court seems to be okay recently on a lot of rulings, but we still have a lot of these weirdo judges out there, even in the appeal circuits down where we are, that just are have their left-wing politics, and they're going to rule that way. So keep an eye out on the channel. Like, share, subscribe. Click the bell notification so you get notified when I post these type of videos, and you can stay up to date with the most latest legal things going on with the firearm community and other firearm stuff. We do a live podcast or live stream every Thursday night around 8-ish. We always have lots of guests. We have a great co-host who is a military person with lots of firearm skills. So if you subscribe, you can check in and watch our live streams on every Thursday at 8-ish. But until then, I'm going to end it here. Thanks for watching. Stay safe, stay vigilant, and as always, carry on.